Baloyi got a shock as Advocate Mshololo stepped forward, calm, razor-sharp, and ready. She drew a clear distinction between executive statements and confessions. And if the state thinks it can sneak in evidence at the 11th hour, guess again. With surgical precision, she alerted the court that Baloyi's moves smell like trial by ambush, a serious violation of fair process. Suddenly, the state's strategy looked more like a gamble, and the house was collapsing. Take a listen at Mshololo, taking Baloyi back to the School of Law.
In this case, my lord, this honorable court has ruled on the admissibility of the statement that is an issue. And when the state introduced this statement, informed this honorable court that they intended to introduce the statement which was referred to as a confession, and the other one was referred to as a pointing out. And when a ruling, my lord, was made, this court, this honorable court, was guided by the provisions of Section 217 and Section 219 of the Criminal Procedure Act. And even the proceedings of a trial within a trial proceeded along those applicable provisions of the law. At no stage wherein it was indicated that such statements were the executive statement. And even when the ruling was given, my lord, it was not given that this statement is ruled admissible as an executive statement, because it was not tried as such. And the trial within a trial was not done for the purpose of admissibility of an executive statement. So the submission that has been made by the state, my lord, which I would want to also read because it is contained in the decided case which my learned friends have referred this honorable court to, the case of Mhlongo and Nkosi, my lord. It's a constitutional court judgment on page 39. I'll just read the two lines. Yes. Common law exception. At common law, there is an exception to the exclusion of extracurricular statement of co-accused if the statement constitutes an executive statement. Close quote, my lord. If the statement constitutes an executive statement. The main issue to be decided, my lord, I submit, by this honorable court is whether the statement made by accused, let me not say whether the statement made, because one day it will be said that I said the statement was made, whether the exhibits.
Who will say that?
The state, my lord.
Oh, the state.
Yes, the state. They will
Okay.
be saying that, yes. Whether the statements contained in Exhibit GG, Exhibit FF, respectively, my lord, before this court, constitute executive statement. If they are no longer the confession, they are now executive statements, then this case is applicable. But if they remain the confession and the pointing out, it means then that this case is misplaced, because the statement that is before this court is not an executive statement. In other words, my lord, the state is doing what is called, or what is referred to as trial by ambush. introduce a statement as a confession, as a pointing out that after the state case has been closed, the state makes submissions that such statement be referred to as an executive statement. My Lord, there is a difference, a huge difference between the two statements. I will highlight just a few differences between the two statements. Confession is made before a peace officer. Pointing out is made before a peace officer. Executive statement is not made before any peace officer or a magistrate, my Lord, in terms of section 217 and 219 respectively. The point I'm trying to make, my Lord, is the difference between the two and the circumstances under which these two statements will be made. Executive statement is not made before a magistrate, it's not made before a peace officer.
Mshololo reminded the court that executive statements are not confessions, cannot be weaponized without proper procedure, and cannot be sprung on the defense like a backstage surprise. She went further, warning that if this court allows the state to sneak evidence in, it risks turning the trial into a circus where the defense must fight shadows instead of facts. Baloyi tried spinning legal reasoning, but the argument had holes big enough to drive a taxi through. At this point, it became clear the state is grasping. The defense is prepared. The law is not on Baloyi's side. Even the bench felt the weight, because the message was plain. Due process is not optional. Fair trial is not negotiable. Let's continue listening.
Then now the statement, my Lord, is before this court. Had we been informed from the beginning that these are the executive statements, my Lord, the accused person would have defended themselves differently and appropriately. And as a result of the misplacement of this submission, the accused rights to the accused rights to a fair trial has been violated. Even if it has not been violated, my Lord, it will be violated if the court allows the state to use the statements contained in exhibits GG, FF, and HH against the co-accused. Their right to a fair trial will be violated, my Lord. And it will render this trial unfair. And also their right to equality will also be violated. As a result, my Lord, it is my submission that this court should not allow the state. I don't know the correct term to put, my Lord.
To allow?
To allow the state to fish, you know, because the state is now saying it's a confession at the beginning. During the trial, it's an executive statement. Alternatively, it's a hearsay statement. It's a hearsay evidence. We're running three parallel regimes. And which one do we need to defend? The status of the evidence that is presented before court is very crucial, my Lord, so that the accused will be able to defend that evidence appropriately. Even if because the problem, if that is not defined properly, the classification of evidence that the state is intending to lead, or that the state is leading, is that at the end of the day, the defense will be expected to make submissions on the admissibility of such evidence for the purpose of conviction now. And then if, my Lord, the evidence is introduced as a confession during 174 is introduced as executive statement, then our arguments, it is not clear as to what is it that we'll need to defend regarding that statement when you are doing the assessment of evidence now, my lord. I submit, my lord, with due respect, that the statement, these three statements, as they have been ruled, they do not amount to executive statements. Now, in this case, my lord, they are not executive in nature. They stay under the provisions of section 217 and 219 of the Criminal Procedure Act. And therefore, the exception that the state wants to rely on does not apply to the statements that are before this court. And they cannot be used against the co-accused, my lord. This is a constitutional decision.
As Baloyi's tactics wobble under pressure, one question remains. Is the state genuinely seeking justice, or just trying to win at all costs? Do you think the court will uphold strict fairness, or allow these 11th hour tricks? Comment below. I want your take. Thanks very much for watching. Don't forget to like, share, and subscribe. And remember, this trial is not just about evidence. It's about the integrity of the system. Stay tuned. We're just getting started. I'm Skybriedge. Until next time, goodbye.